let's explain to folks what's happened here. So the Trump administration last night, with the power of a pen, withdrew what President Obama had done as far as protections for transgender students in public schools that let them use the bathroom corresponding with their gender identity.
The Trump administration says it is a legal, not moral issue, that President Obama did not offer enough evidence that a federal education law protected transgender student discrimination. So President Trump's Education and Justice Department will not enforce it. The Trump team now says which bathrooms transgender students should use will be up to the states, not the federal government.
Constitutional scholar and attorney Byron Henry joins us right now to help us make some sense of this madness. Should I be up in arms over this? Is anything going to change? It strikes me that, feel free to correct me if I'm wrong, I am not on your level. The Obama era order never actually went into effect because a judge put a hold on it already.
Well, that's right. Thanks for having me, Bruce and Pamela. You're exactly right. The President Obama's directive from the Justice and Education Department said that we're going to look back to Title IX, which everyone knows was a groundbreaking piece of legislation to help increase women's participation in athletics and other extracurricular activities in schools, colleges, and public schools. Basically looked back and said, we believe that the word sex in that discrimination statute includes gender identity, which would force schools to treat those who identify as a sex different than their birth gender, however they identified, and it applied to restrooms and locker rooms and overnight trips and dorm rooms at colleges. And shortly after it was entered, a lot of people voluntarily complied, a lot of school districts and government, but the ones that didn't, a lawsuit was filed here in Texas, and a district judge in Dallas blocked the new guidance and said basically that the president lacked the authority to basically reinterpret the Title IX to include gender identity, and that's, I think, a lot of the reason why President Trump's administration rescinded the guidance, because they believe that it had some legal issues. But nothing ever really changed. The law stayed the same from the 1970s. The directive never went into effect. All it did was call a lot of attention to it and basically drive a wedge between transgender individuals and local people in cities and school districts where it seemed like they had been getting along, and I assume there had been transgender people using restrooms and other facilities my entire life, and I never noticed it until this blew up over this whole bathroom directive issued by President Obama's administration.
We're speaking to Byron Henry. He's an appellate partner at Scheef and Stone. Look at that. That sounds important. I wish I had that on my business card. Byron, is there also a issue? Am I to understand that the Supreme Court has already agreed to look at, if not this specifically, the broader issue of, I'll use the term, a patchwork of laws when it comes to transgendered rights? So can all this become moot should the Supreme Court rule on it?
Well, that's a great question. There is a case out of the Fourth Circuit which comes out of a school district in Virginia that was sued and actually was ordered to allow, based on this guidance given by the President Obama's administration, the Circuit Court of Appeals there based their decision on this interpretation of the law, and now that it's been rescinded, one would ask whether or not there is actually any basis for that decision, but it has been taken by the Supreme Court of the United States, so there's a number of things that they could do. They could simply dismiss the case. They could remand it and let the Circuit Court of Appeals look at it again, because now there's no guidance from the executive on how to interpret Title IX with respect to gender identity, or they could still take the case and rule definitively whether Title IX applies to gender identity. And so it'll be interesting to see what position the Trump administration takes on that. But the Supreme Court has granted the petition in that case to hear the case later on this term. And the other question is will President Trump's nominee, Judge Gorsuch, be confirmed in time to hear arguments or participate in the decision in that case?
Byron, we're almost out of time, but I got one last question for you here. I know that there are a lot of administrators and school board members that listen to our show. What does this mean on a state's level to the people responsible for running schools? What do they do at this point in time?
Well, I think both the directive and the law before the guidance was issued by President Obama is simply you work with your school district and parents to try to balance privacy and security interests of students with also safety interests and making people feel included and not discriminated against and to stop bullying. And the real issue is if there's not a state law dictating how this has to be handled, it's going to be handled locally at every school district and every city level and balancing the interests and listening to parents and teachers on how to best address this, which is what was happening in what I understand was happening before the guidance was issued.
Agreed. All right.
I appreciate your time this morning. Thank you very much for helping us better understand it. That's Byron Henry, a constitutional scholar and an attorney at Scheef and Stone.
We want to know what you think of the president's decision.